on the complaint. But here is not, here we are talking of, here we are concerned with the rights of a particular individual of conscience, right of the religion and conscience. That satisfies the laws of the well.
What impact would that have with regard to the practical implication of creating a restriction? Personally, my view is that some article 1 of Article 25 is not a substantive provision. It's only a guideline which has been given to the government of India under this Article 25 to formulate a certain process of law for the purposes of practicing the regulation.
Ultimately decide that it is substantive right, but the Constitution Assembly was aware of the diversity and the reform which may need to be introduced in the country. That's why the Constitution Assembly put three inhibitions, and they are sufficiently catered to the needs that subject to public order, morality, and health, and to the other provisions of the part, all persons are equally entitled to freedom of conscience and the man of disputing the right of the word and the right freely to profess, practice, and propagate religion. The subject, the reason which they are subject to public order, morality, and health. My position is sufficient to cater to the needs of state and society as a matter of.
So let me formulate my question. My question was, what is the relevance of the use of words subject by the Constitution under Article 1 of Article 25?
Any issue of public order arises emanating from any religious practice, then this the right must kneel down. Right must kneel down before public order, morality, and health. This is the understanding which I take of that particular.
See, read 25 2. This is another, here the case was that a notification was made banning hazard. That's right. Here you are trying to make out the case, the state government came with a notification under the Education Act and whatever it is, where the hijab was banned. Now see, if you say Article 25 was 2, nothing in this article shall affect the operation of any existing law. Now, mark the word, or prevent a state from making anything. Notification is a part of law. Regulating or restricting any economic, financial, political, civil, military, or other secular activity. Right? So, in order to ensure that secular activity toward participation, the government still can make any law. Now, in a secular state like India, if the government comes with a notification banning that, will that all follow Article 25 plus Article 2?
In my humble submission, the notification does not come under the purview of Article 2A for the reason I will state this way. It says the clause A starts regulating or restricting any economic, financial, political. First, there are three: economic, financial, political, or other secular activity. My lords, the hijab is neither associated with economic,
No,
financial.
not all economic, financial, political. I am only confining to the word other secular activity.
In my humble submission, hijab is emanating from the right to conscience and religion. It is not a secular right. It is emanating also, hence it does not come into the purview of Article 25
All right. You stated about the intent of the framework of the Constitution by way of Constitution Assembly debate, stating that they were well aware about that. So, if you just refer to the explanation to this article, whatever they were clear they have written in that, the wearing and carrying of Irfan shall be deemed to be the included in the provision of Sikh religion. No other thing has been mentioned. All 5K, which is possessed by Sikh religion, K, Sangat and all, they are all there.
Wearing and carrying of weapons can be deemed to be included in the protection of the
That is the intent of the framework of the constitution. It's very clear.
I may answer this question. I must put a question to myself. Now, explanation one doesn't say that turban, but I am wearing a turban. Would your lordship say that leave the program, how can you express your religious expression and in a secular group? The answer is in my humble speech is no. Because this is the aspect, which is the positive secularism, which the lordship has evolved, that to respect the religious without interfering with them. So there are lots of religious practices which have not been mentioned in Article 25, but still are they are protected.
All right, move on.
If I may draw your lordship's attention to the notification, specifically targets hijab. In my humble submission, it smacks of malafide intention. Had they been bona fide, they would have said that no religious expression is allowed. They said no, hijab is banned. My lord, even the lordship is my the judgment is at paragraph at page number 77 of the compendium, has read secularism article 14. It is the aspect of equality that the state shall not discriminate on the basis of religion. My humble question to myself only is why only hijab? At the intentions in bona fide, the state has said that all the religious expressions are banned. They said no, only hijab. But that is on the base of discriminatory. Another aspect is Article 19. My lords, in National Legal Service Authority Constitution of India gave authoritative pronouncement that press is an expression in the meaning of Article 19 of the Constitution. My lords, if at all there is a restriction, the restriction must be proportional. The lordships in A.S. Puttaswamy settled that while imposing the restriction on a fundamental right, the state should adopt least restrictive approach. Now, my lords, here the principle of the reasonable accommodation comes into play. My lords, I want your lordship to take note of the point before I delve into the issue that we do not have any single objection to the uniform. We are merely contending, please allow us to cover our head over the uniform. We are not saying that we are against the uniform or we are against the equality. We are merely saying that please allow us to wear a uniform. My lord, that even the lordship Supreme Court rules and bar council rules says that even the Chief Justice, that the second Chief Justice of India, the Patanjali Shastri would wear tilak. That is the positive secularism that we have evolved in our country. Now, my lord, there are international judgments. The principle of reasonable accommodation comes from the jurisprudence of South Africa and international judgments. Now there is a Canadian Supreme Court judgment at page number 87, which clearly covers the present case, and it may be of great assistance to you. But in that case, 87, the highlighted portion. Page number 8. My lord, the kirpan was banned. However, our constitution provides explicit exemption. In their constitution, the Article 25 is almost perimeter, the right to religion. The kirpan was banned. Ultimately, the matter came before the Canadian Supreme Court. Now, the Canadian Supreme Court said that it was a case concerning with the school where the at paragraph number 76, the ratio, this is the majority ratio. Religious tolerance is a very important value of Canadian society. If some students consider it unfair that Gurwaj Singh may wear his kirpan to school While they are not allowed to have knives in their possession, it is incumbent on the schools to discharge their obligation to instill in the student this value, that is, as I will explain in the next section. My lord,
All
here,
right, one good. We're talking about the reasonableness. Reasonableness is such a word. Has it been defined anywhere? Or there is some criteria to take what is reasonable and what is not? Who is authorized to do that? We would like to know your opinion on this.
as I have interpreted the law, yes, given law very clear constitution proportionality. My lord said that the restriction first should be rational. Second, it must be legitimate and must be within the purview of Article 13, the law. And the third is, it should be the state while imposing it should adopt the least restrictive approach, and there should be a direct nexus to the object which it vows to be achieved. My lord, this is the criteria which your lordship laid in the case put us on.
Now, Article 13 that defines the law. Now, in case if you say that that has to be reasonably construed, then why Article 25 explanation 1 and 2 have carved out an exception to a particular religious group?
In my humble submission, the explanation which the Constituent Assembly put in the Constitution was somehow political. They know that this is a sharp object, it's a weapon. Now, because the Constituent Assembly did not give right to weapons, so it may, the situation might have arisen targeting the state. So the Constituent Assembly deemed appropriate to provide explicit exemption that the ban, since it is emanating from a religious practice, must be exempted and be allowed under the Constitution. That, in my humble submission, my
So, you know, whenever that explanation 1 and 2 was introduced, that explanation, whenever it was introduced in Article 25, at that particular point of time, this Muslim community, where this customary rights of putting on hijab was prevalent. Now, why didn't the Constitution, in its own wisdom, incorporated that in your explanation? Permitting of an hijab. Why this exception was carved out? Did it not be wanted to
because the Constituent Assembly did not see any conflict arising from the hijab. It was, the practice is very innocuous. So Kirpan was a weapon. So conflict might have arisen. To avoid that conflict, the Constituent Assembly deemed it appropriate to exempt it. But the hijab is a common practice which is prevailing all over the Muslim or practicing society as a matter of. But since it was a sharp object and weapon, they deemed appropriate to put an explicit exemption in it. However, there are so many practices which are protected by your lordship, but not mentioned in the Constitution, but still protected by Article 25 of the Constitution.
No, in that way, in case if I accept your answer, then I think putting on a hijab would be more illegal than carrying a weapon. Looking to the present scenario, where there are so many terrorist activities going on, that would be more lethal than another. Somebody covering and camouflaging herself.
My lord's concern is required to be addressed, and I will satisfy your lordship on this answer. That hijab merely covers the head, like I am covering my head with the turban. It does not put any, it does not bring or invite any security issues. I can cover my head. They also can cover the head. It doesn't cover the face. It merely covers the head and the upper portion of the body.
You give up the argument where you have to essential religious practice, or you still insist upon that?
My humble submission is that there is no application of essential. In my humble submission, I state on record that there is not a single authoritative pronouncement by your lordship, and that's why the matter has been ultimately went to the ninth judgment, that whether in isolation Article 25, whether it is application on Article 25, the matter is pending before the last judgment. So even how the matter will be tried, my lord, if the matter which is practiced does not offend morality, public order, and health, it forms the protection.
What I want to say, you want to say that essential religious practice argument, you are not insisting upon, you are giving up that argument. It is not a part
your lordship, if at all inclined to apply the essential religious practice on Article 25, I will satisfy your lordship on that aspect too. If, now, madam, but the question is, I will ultimately satisfy on it, but the question before it arises, how to decide the essentiality? Now, in Commissioner of Police versus Acharya Jagdishwaran, the previous bench of this honorable court said, it must be a fundamental to that religion, and changing in that practice must cause changes to fundamental. Whole religion must change, but in schedule must change. That is 7th Constitution but address it.
My question to you was, are you relying upon ERP argument or not?
Madam, my humble submission is there is no need to delve into essential religious practice at all. But if at all your lordship say that no, there is application, I will satisfy on that aspect.
For you to decide. Are you giving up the argument of ERP or you want to continue to the argument of ERP? For you to decide.
In my humble submission, I am not giving, but if your lordship call upon to satisfy that no, satisfy us on the essential religious practices, I will be satisfied.
Just answer me one question. Just tell me whether law should be progressive or not, and especially in a case where a girl child is involved, she is entering into college or school premises, and for her overall development, what should be the law possibility?
My lady, I respect your opinion, but that we have to accept this unfortunate reality of society, that society is still rigid when it comes to custom. One of the omnibus ban on hijab in all the education institutions could be a chilling effect on right to education. It is the essential, the practice is so embedded in the religion that they will choose to withdraw their girls from the schools and education institutions. And your lordships having Joseph Stein versus Union of India, all the majority judges were in the coalescence on the opinion that practice, though it be asymmetrical, the reformative opinion of the neither of this constitutional court nor the state would encourage such practice, as long as it is within the confines of Article 25 of the Constitution.
But we have seen that at times law has reformed the public opinion. That the Sati case, if you say though that law should not be made like this to prevent something which is not akin to the progressive society. But this is the counter thing that law should be made like a public opinion with the public opinion. At times, public opinion is modified by the framing of laws.
I'm waiting that your lordship has asked this question. But the question arises, and I must pose question to myself only, how hijab of ban reforms the educational rights of a female student? It doesn't. In fact, it will have
No, you're not correct in that. If a girl child wants to take education in a particular school, which according to the society or her parents is the best school, and she wants to take an education in that particular school, now she is denied the entry for that. So don't you think that the law should be, what he said and what I am saying, that law should be progressive within the four corners of the Constitution, how it is to be decided? If you were the judge, what will you do?
in my humble opinion, now a girl comes wearing hijab, she wanted to take education in a particular school, now only because of her right to religious expression. Now we are saying you give away your right to religious expression, and in order to get education.
Don't you think there is a conflict between education and religion at that time?
That is the right query, which is a moot question for your lordship consideration, that a conflict of fundamental rights. One side is the right of education and religious expression. Your lordship at page number 74 said that there cannot be watering of fundamental rights. All the fundamental rights must be given harmonious conception.
We should proceed. The right of religion,
Right of
right of education.
that in my perception, that's the option choice. There is no choice at all.
Right of religion can be an absolute under the Constitution.
Not in any manner it can be excluded. There are indications in the article itself, but it cannot be put against the right to education. wants to take education in a particular institution, she should not be denied merely because she is covering the hand. My lord, that restriction is itself irrational in my humble submission.
Let's go beyond this, that this girl, among thousands of students, she wrote an examination, ended the examination, and then she was selected for this particular place, school or the college. And just because of this small thing, she's denied entry. So how do you balance it? See, we all know that this matter is pending before the Supreme Court and two judges have given different verdicts. And it is still not yet decided. So we just want to know from you, what is your view?
My humble submission is that
All right. All right, on the last question, before this court allow you to move further, it seems that the whole thing is revolving around the concept of reasonableness. It is there, if it is reasonable, it will be denied if it is not reasonable. So this court has given the authority long back in the case of Arunachal Nazar. Are you aware about that?
perhaps right now I'm not aware of that question, but if it assists your lordship, I will come up with the, it will help the adjudication of the matter. But your lordship may put the ultimate question. What is the question?
So the court has already given the guidance what the reasonableness would be. Right?
My lord, whatever has been laid down in the case referred by my lords, it must be in consonance with the judgment of the Uttaranchal. So here Uttaranchal just bringing down all the law on the reasonableness. So the criteria which your lordships lay down, that it must be rational and it must be legitimate and come to the
Move on.
my lord,
Why it is so unreal? Then why it is so that many developed countries they are completely banned in that?
my lords,
And
because
they
the
have developed countries
secularism
and-
which we have evolved and adopted is different from that so-called developed countries, my lords. They have been
Constitution itself might be borrowed from developed countries.
my lord, please.
Your constitution itself and anything that can be borrowed from the constitution of
But constitution says, it is this court interpret. This court has interpreted that constitution is intending that there should be a positive secularism. Now, the positive secularism means I wear uniform, but I will come. That is the aspect of positive secularism. Now, I will move forward to the second contention. Now, we attach the constitutional 106 constitutional amendment as it violates the basic structure of the constitution. My prime move's proposition in this regard is that constitution cannot be used to withdraw its allegiance from the constitution itself. Now the constitutional amendment says, now the parliament has made the constitution say that the constitution is now saying that you withdraw your allegiance from me. But that is destructible to the constitution. Constitution cannot say you can withdraw your allegiance to me. That is destructible. And it conforms to the ratiofication of Bharati case. The lordship, I will quote the judgment of the lordship Justice Grover and Sutherland. They said that constitution cannot be legally used to destroy the constitution itself. So my lord, the amendment says that now constitution is saying that you withdraw your allegiance from the constitution. It is destructible to the constitution. And this court being the sentinel and guardian of the constitution. And the, I will submit to vehemence that the iron hand of your lordship must blow on such action. This is self-destructible to the constitution. The constitution cannot say you withdraw your allegiance from the constitution. My lord, second is that the amendment is hit by the principle of federalism. My lord, the federalism, as in Keshwanand Bharti, in Asa Mumbai, have very succinctly expounded the concept of federalism.
All right, one. The government is not party to the UDHR, International Civil and Political Rights Convention. If yes, what is the benefit?
Indeed. The Indiana is one of the founding members of the United Nations and it recognizes the right to self-determination. I must clarify that present it is an obligation. But my lord, the law is settled. The international law cannot dictate the constitution. The constitution, when there is a conflict between the domestic law and the international law, the domestic law will prevail. Now the constitution, as the interpreted by your lordship, it says that it cannot be used to.
So you mean to say, whatever is comfortable to you, you will accept that out of the entire document, irrespective of the fact that you are the signing authority in that.
That is not my humble submission. My humble submission is we have to respect the international obligation. The parliament has to respect the international conventions and laws. These exactly, but the supremacy is of the constitution. But once the moment constitution says the contrary, it has to prevail. That is the law which your lordship laid in the beginning of
This court want to know,
Please.
if it is against the provision of the constitution, what made us to sign the convention?
Hello? It is not that self-determination is against the constitution. It is the session which is against the constitution. Now, we got it. I want to lodge that it must be the respondent side must explain as to what is the value of self-determination. Self-determination to be deciding the authority governed, then we have the universal adult franchise. The people decide their government, but the constitution is supreme. It is inviolable.
You want to say that self-determination means a type of democracy.
Yes.
Democracy is also self-determination, meaning thereby that you elect your own government. This type. But come to another point. At the same time, you are also advocating that the state should be given the right to citizens. At the same, once this constitutional amendment is declared unconstitutional, how you can then ponder upon about issue number 4? No, what I am saying is you are arguing against you.
I know. In our petition, we are against the right to secession to the state of Croatia. Please refer to our session of Croatia. So we, in my humble submission, we are not contradicting. We are saying that constitutional amendment is invalid before right secession, and so there should not be any right of secession to the state of Croatia. That's it.
What I am saying is you are a petitioner on all the 4 issues. All the 4 issues. There are 4 issues before this court. The 4th issue that you are arguing about, that the state should give a right to secede from the union. Once this constitutional amendment is struck down by this court, how you will press upon issue number 4?
We are not pressing upon issue number 4 in an affirmative. We are saying that no right should be given. Please, my lord, may refer to our prayer. We are saying state of Croatia should not be given the right to secede from the union.
Therefore, 106 amendment is unconstitutional.
In our humble submission. That is the answer. Now, if as the concept of I was aware in general statement is limited to 9 judgments of constitution bench and the SR rule. It was made clear that there is a slight contrast with the federalism in United States of America or
Concluding within 1 minute.
but the concluding my submission is that federalism because now my lord, I test which I did before your lordship is that in order to a state to have a right to secede, it must have a sovereign identity before its incorporation to the union, as part of like the US. But here is not the case. As your lordship
In that case, the only question is, in your opinion, you are federal or unitary?
we are not neither a federal or unitary. We are quasi-federal, as your lordship recognized in state of Rajasthan versus Union of India. That there is a division of power with a strong bias towards center.
No, this court expect that you should go beyond the Professor Vyare. There are some other opinion, and this court also has given opinion on this during question and answer. Right?
The law has been settled by your lordship in SR Mumbai also in state of Rajasthan that the India is a quasi-federal and the Constituent Assembly was aware the last in my line, I submit that the preamble, it says that unity and integrity of India, madam, it directly hits that unity and integrity of India. The Lordship in Jerubari, unit, though had, that preamble is not a part of the Constitution of India, but the majority decision station on Bharat overruled this proposition. There's that no preamble is a part of Constitution of India, and the Lordship in Esther said that its components of preamble tells what constitutes as basic structure, though not exhaustive. Now the unity and integrity constitutes as basic structure, and the amendment directly hits that federalism, and in my humble submission, it should be struck down as I humbly.
Greetings to the Honorable Bench. I would be representing the respondent in the pertinent case, and I would be assisting the Honorable Court in contention number 3 and contention number 4. If the bench is well seated, I request to move to contention number 3.
Please hold on. Petitioner, second.
Uh,
Okay, all right.
Majority. Your Honor, contention number 3 is that the imposition of president rule in the state of Kalushia is constitutionally invalid. Your Honor, before getting into the arguments, the Council seeks permission to bring forth the intention of the Constituent Assembly, which was present at the time of drafting this article. Your Honor, when Article 356 was being drafted, there was a question which came before the Constituent Assembly that if this article makes it to the Constitution, it could transform the Union of Indiana into a centralized form of government. And to answer this, B.R. Ambedkar expressed his view that this article is in no way in contradiction to the federal structure of Indiana. And the reason he supplied to this argument was that this right, the power which is given under Article 356, should be judiciously used. It should be used as a last resort, and it should not be applied in every other case. Your Honor, B.R. Ambedkar was of the view that every interpretation which is to be given to Article 356 should be given in consonance with the federal structure. And this view was also upheld in the case of S.R. Bommai versus Union of India.
One question before you move further. Now, this interpretation of 356, this court would like that you come up under the backdrop of Article 355.
Majority. Your Honor, Article 355 of the Indian Constitution states that it is the duty of the central government to protect the state government from any external or internal disturbance. Now, Your Honor, Article 350, when read with Article 355, Article 356 would also prove to be a duty or an obligation which is obligated on the President to protect the states. Your Honor, the Council humbly submits that as it is a duty, the scrutiny which is associated is more in degree as would be associated with the power. And this duty should be judiciously exercised wherever it is required. And this duty should not be exploited due to bona fide reasons.
Just tell me one thing. Article 355, yes, if it is to be read in consonance with Article 356, whether they are in contradiction to one another or they have got a different object to be achieved.
Your Honor, this question came in front of the bench in S.R. Bommai, and the bench of S.R. Bommai was of the opinion that these are not in contradiction. The Article 355 is in consonance with Article 356, and they both are in consonance with the federal structure of the Constitution, and they should be read together so as to be interpreted according to the concept of federalism and to protect the dignity and the functions of the state.
Look, I think it's subjected of the two articles. They are entirely different. My view is that these two articles have got different objectives to be achieved. see Article 353.
Your Honor, I should plead this. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure.
So this is an article which entails the government's responsibility to maintain a certain object which is contemplated under Article 353.
Your Honor,
How would you say that it goes in harmony with the objectives contained under Article 356?
Your Honor. Your Honor, both of these articles are in consonance to each other. It is just the scope of these articles that is different. Your Honor, Article 355 imposes a duty on the Union to see that constitutional provisions are being obeyed by the state. Your Honor, Article 356 states that if the Union is of the opinion that constitutional provisions are not being followed, then they can impose president rule. Your Honor, Article 355 merely states the intention, and Article 356 states the action which this Union has to take if Article 355 is to be complied.
Another question I want to ask you related to this only.
Your Honor.
Where 355 says that the state, the union will take care of two things: external aggression in the state and internal disturbance.
Yeah.
So, what do you understand by that?
Your Honor. Your Honor, external aggression would mean in this context that if the problem which is being created originates externally and not within the state. It might be an attack from a different state or different country. But Your Honor, internal disturbances would mean the disturbances which have arisen within the state, as in the present case. The protest which is being done by they are the people, they are the resident of that particular state. Your Honor, according to council, that is the difference, that is the intention which was
Now, in the present case, government has lost the majority.
yeah.
So there was no clear option to form a government. So it is not a breakdown of the constitutional machinery to impose the presidential rule under Article 356.
Your Honor. Your Honor, the council agrees that there was a breakdown of coalition government, but the council humbly submit that president rule should have been imposed, and it has to be imposed as a last resort. Your Honor, there should have been a flow test. The provision of flow test has been held mandatory. Your Honor, when the function of the governor came in question in Vijayananda Patnaik versus Union of India. Your Honor, in that it was held that because Article 356 has been taken from Government of India in 1935, which in turn was taken from the British Constitution. Therefore, to interpret Article 356, we have to take help from British Convention. And Your Honor, it is a settled law in British Convention that before imposing president rule, flow test need to happen. Your Honor, in the present case,
But was there any party who has claimed majority?
Your Honor. Your Honor,
As per the statements or as per the facts available, there was no party which claimed majority in the house. So in such a case, till somebody come up with a case that he is having the majority in the floor, how you can say that the imposition of president rule was wrong?
Your Honor. Your Honor, the council humbly submit that it is the duty of the governor to ensure that the state works within the framework of the constitution. And in regard to this, it is the duty of the governor to ensure that there is a state legislation. And if to perform this duty, the governor is to send an invitation to the political parties, which according to him demands majority in the house. But if according to him there is no such political party which commands authority, he should ask the members to vote and to choose their leader.
All right, Mr. Foster.
Your Honor.
Just you see the language of the article.
Your Honor.
The President of India is satisfied on the report of the governor of the state or otherwise. The otherwise one need a lot of interpretation.
Your Honor.
So it is covered in the time.
Much obliged.
If governor is duty bound, what about the nation? The President of India?
Your Honor, the council humbly submits that flow test should have been done, and it is one of the most important ingredients, and all the other remedies should have been exhausted before applying before the imposition of president rule, and the same is held in SR only. But to satisfy the query of Your Honor on the word otherwise, Your Honor, the otherwise word as it comes in Article 356 should not be given a wide import. It should be restricted, Your Honor. The word satisfaction of the president as it arises in Article 356, the satisfaction of the president should be based on an objective material which can be inferred that there is a breakdown of constitutional machinery. Your Honor, the satisfaction of the president is not equal to his personal whims and fancies, and he cannot just impose president rule on such trifle and such small problems as they come in the state. Your Honor, also in regard to the breakdown of constitutional machinery, the council humbly submits that there was just a mere protest without any damage to the public property or to the private property, and this has been very well mentioned in the Moot prop that there was no damage to public property or to private property.
All right, move on.
Your Honor, and thus this, Your Honor, I should delve on this breakdown of constitutional machinery. Your Honor, and this protest can in no further stretch of imagination be taken as a breakdown of constitutional machinery. Your Honor, in Thiru K. and Rajagopal versus Thiru M. Karunanidhi, even the dissolution of the legislature was not held as a valid ground for breakdown of constitutional machinery. Then how can just a breakdown of coalition government be taken as a valid ground? Your Honor, on page, if you refer to page 60 of the compendium, on page 60 of the compendium is an excerpt from the case of S.R. Bowman, and it states that there should be measures should be taken and protest should be done. But if in any particular case the circumstances are such that protest could not be done, then it is the duty of the governor to give to the president in writing the cause why protest could not have been done, and all the measures should be exhausted before president rule is imposed. Your Honor, the council humbly submits that this is an arbitrary use of power and there is a mala fide intention before this imposition of president rule. Your Honor, it is the first time that a different political party from ISP made it to the state legislature. And Your Honor, this is the same government which holds authority, which has the government at the central level. Your Honor, this case was dealt in S.R. Bowman, and it was held that just because when president rule is imposed to do away with the political code.
As per the proposition, the party supporting your government has already withdrawn the support. And situation in the state is worsening day by day because of the agitation.
Yeah.
So how do you say that it is necessary to have a floor test when they have already withdrawn? Already withdrawn this, they might have given affidavit to the honorable governor of the state.
Your Honor, the council humbly submits that India being a democratic nation, there are a lot of political parties, and in so much political parties, these small political disturbances are normal. There might be a case IJP would not be able to form a government with ISP due to political disturbance, but IJP might form government with some other political parties. It is not just that ISP and IJP
Do
are
you know the practices, British practices which you are quoting? That is not even given the last resort to form a government with the collaboration of such parties, those who are trying to form government, only for them. It's not only last resort, it should be avoided, that practice which you have quoted shows that. What do you say about that?
Your Honor, India is a democratic country, and if measures are to be taken to control the agitation, then parties can come together, and if their ideologies match, then there is the council humbly submit that there is no restriction on with whom the party wants to come in
In
coalition.
other words, you want to say that the powers given under Article 356 is not an absolute power.
Yes, Your Honor.
It has to be scrutinized by the president or the governor based upon the material which is placed before him to satisfy. So
You need, Your Honor.
the use of word satisfy is that there has to be a material before the court,
Yes,
before the governor or the president.
Yes, Your Honor.
That is what you want to add.
Yes, Your Honor.
Now one more thing. This question which is posing before this bench is on the reference of presidential reference. Is Is it the same? So whether this court is obliged to answer this presidential reference?
No, Your Honor.
Because if you go by fact, the government which was formed in the state belongs to a particular party, IJP, and the central government was also of the same party, IJP. When this presidential rule is imposed, which party lost the power? IJP. And IJP have not come before this court seeking any grievance from the presidential proclamation of imposition of the emergency.
Yes, Your Honor.
So how this court should, why this court should give an opinion on a redundant issue?
Much obliged, Your Honor. Your Honor, the council humbly submits that this case has not come under the presidential reference. There is a writ petition which has been given by the ex-CM Akhanda Tripathi, and this is the petition and not a presidential reference. The presidential reference is with regard to contention number 2, whether Article 106 is constitutional valid. Much obliged, Your Honor. If Your Honors are convinced, the council seeks permission to move forward to contention number 2. Your Honor, the contention number 4 is that the state of Kaloshia cannot be given the right to secede from the union. Your Honor, as it has been very well established by my co-counsel that the 106th amendment is constitutionally invalid, and if that view is upheld by the learned bench, then the question whether the right can be given to Kaloshia or not does not arise. But to still appease the query and to satisfy the bench, the co-counsel would deal with the contention. Your Honor, Kaloshia is a very peculiar state. It is the only state which practices the religion Drakism. The majority of the people belonging from Drakism religion are present in Kaloshia, and they are not found in other parts of the union very prevalent. Your Honor, the people of Kaloshia are only demanding to secede from the union on the basis of their religious differences. And Your Honor, if Kaloshia is allowed to secede from the union based on religious differences, this would hit the principle of unity in diversity, which is practiced, professed, and propagated by the Union of Indiana. Your Honor, if Kaloshia is allowed to secede from the union, this would also be hit by the concept of federalism as it has been very well established by my co-counsel. Your Honor, if Kaloshia is allowed to secede, it would also be hit by the concept of secularism. Your Honor, Kaloshia is one of the most important states in the Union of Indiana. More than 10% of the GDP of the country comes from the state of Kaloshia. Your Honor, if Kaloshia is to secede, it would not only impact the people of Kaloshia, it would impact the whole country of Indiana. Your Honor, and thus this against the principle of secularism.
All right, one question.
Your Honor, the council wants to clarify it is not against the concept of secularism, the council intended to say socialism.
All right. Now, as you said that in this case, state cannot be allowed to secede from the country.
Yeah.
On so many grounds.
Yeah.
So, as per this amendment, there are two things. One is referendum.
Yeah.
If it goes beyond that, and you are talking about a state which give maximum GDP to the Union of India.
Your Honor, the second part states that if 50% of the people vote in favor of secession, then the state would secede. Your Honor, even this is flawed that how can 50% of the people, by just simple majority, can decide the fate of
This is conjunctive, not subjective, because the word is and.
Your Honor, the referendum would be valid. If 20% of the people vote in favor of referendum, the referendum should be done. And once the referendum is done, In the referendum, if 50% of the people state that yes, we want to secede, then they would secede. Your Honor, both of these provisions are flawed because how can a portion of the population be granted the power to decide the fate of so many generations to come? Your Honor, while I say this, I would like to bring forth the condition of India and Pakistan. Your Honor, the condition of India and Pakistan at the time of partition seems to be very similar to the facts of the present case. Your Honor, India and Pakistan, the most deciding factor between the partition was also religious differences. And Your Honor, the condition which is prevalent in India and Pakistan today is very dire. And thus the Council humbly submits that if the state of Kalosha is to secede from the Union of India based on religious differences, it would not be in the interest of the people. And other measures need to be done as secession is never the answer. Your Honor, I also pose a question to myself that how can an expressed provision of our constitution, that is the protection of unity and integrity, kneel down before an unexpressed provision of our constitution, which as the respondent demand, that is self-determination. Your Honor, if Your Honors are convinced with the arguments, the Council seeks permission to move to the bill.
Come for the prayer.
Your Honor, in the lights of the facts of the case, issues raised, arguments advanced, and authorities cited, the Council on behalf of the petitioner plead before the Honorable Court to kindly adjudge and declare that the notification banning hijab is constitutional and does not violate Article 19, Clause 1, Subclause A and Article 25 of the Constitution of Indiana. That
That's the no. You are for whatever they are asking to the applicant. They are asking 136 petition.
Yes, Your Honor.
You can challenge the judgment of the High Court, where it was held valid. Yes.
Notification.
You are now saying.
No, Your Honor. We contend that the notification is unconstitutional.
No, but you have just said that it is.
It's a contradictory argument.
Yeah, no. You have just said that it does not violate Article 19, 1 and 25. Which is just, the contrary to the argument your colleague has just made. You are from the place of the right?
Your Honor.
And you have said that you are not supporting the current High Court judgment, rather you are trying to reduce it to the right. So you are against the notification. But when just let your prayer for the notification.
Your Honor, the Council begs indulgence with much respect of time, Your Honor. May I proceed, Your Honor? That the 106 Constitutional Amendment is constitutionally invalid, and the imposition of President rule in the state of Kalosha is invalid. That the state of Kalosha cannot be given a right to secede and or pass any other order or grant such relief as the bench will deem fit in the best interest of justice, equity, and good conscience. And for this act of kindness, the Council on behalf of the petitioner, as in duty bound, shall forever pay. It was an honor to me.
You are against the motion.
are getting with issue number?
One and two. Your Lordship, the first issue deals with a petition filed by the joint petitioner claiming any fundamental rights and liberties under Article 19 clause 1 subclause A and Article 25 clause 1 of the Constitution of India. For the convenience of the court, I would be dealing with each of the submissions separately, but I refer to one out. The counsel these submissions will move on to the funds. Your Lordship, it is humbly submitted before you that the restriction imposed on the fundamental rights is reasonable in light of the reasonable restrictions imposed on Article 19, clause 1 of the Constitution of India. If your Lordship can please refer to the case of A.K. Gopalaki versus State of Madras, given on page 17 of the Moot proposition. In that case, the Honorable Supreme Court had held that it becomes crucial at times to restrict the fundamental rights, as under certain circumstances, individual liberty can be subordinated to the other larger interests of the society at large.
One question, if the object is to provide education, how does it matter if someone enters without headgear or with headgear? Number one. Number two, how can it be said it's a reasonable restriction? You are saying that this is reasonable restrictions. Now, in hijab, if the amount and the object is to impart education, if somebody doesn't put the hijab, so do you think that he or she should be barred from the education? So how is it reasonable restriction?
And I will just add one more thing to what Mr. Upadhyay and Mr. Tripathi is saying, that how and who decides the reasonable restriction and what are the parameters of it, in your words? Your Lordship, answering the first question, the matter of the fact is that schools, particularly education institutions, they have to maintain a parity among all the students, considering the uniform. Uniform forms an integral part and parcel of these education institutions, as postulated in international case, which I would refer to Employment Division versus Smith. In that case, the court has said that if a uniform is religion neutral and universally applicable to all the students inside the classroom, it cannot be said to be discriminated in any manner. To maintain the decorum and to maintain the parity in the uniforms described, the schools have to make rules that the students adhere to these education institutions and these schools describe.
Well, that eventually whether this restriction will not be moderated by Article 21.
The Lordship, the matter of the fact is that this would not be violative of Article 21, considering that Article 21 also has certain restrictions under it. If you talk about right to privacy, it has restrictions under it. Right to education.
Article 21 doesn't have any restrictions. Article 19 has restrictions.
Article 21 under right to privacy has restrictions, not under right to privacy.
So how can there be a deprivation of an individual to have education merely because of the fact that the uniformity of the uniform, which is you say that it is of importance?
The matter of the fact is here that even the education institutions as a group also have the right to manage their own affairs and to administer their own affairs according to their own rules. And this also is in line with the fact that they have to maintain a consistency among all the students in these education institutions to be abiding by all. The children should be abiding by all these rules. The fact that it would not be based upon intelligible differential if there have been different rules applicable for the ones who wore hijab or the ones who did not wear hijab. Another important factor in this sense is that in this particular case, under para 30 of the Moot proposition, it is specifically mentioned that it is not particularly hijab that is banned, but any uniform that is not proper and not in accordance to the education institution rules, that collectively is banned. So it could be either hijab or any other religious practice.
Can you read the particular provision by which this has been banned? Specific provision. It cannot be unreasonable for the Sikhs, and there is a carve-out exception in the Constitution. How can it be unreasonable for someone who wears a hijab? And how can you say that a infirmity in the uniform will affect the whole object of the education? I am very failing to understand it. In the particular provision, in fact, what has been banned? Only hijab or many other things also.
Your Lordship, we are provided with a more proposition and not with the section 133, but the fact is that if your Lordship could refer to the para number 31 of the proposition.
Yes.
Your Lordship, under third class right, it says that under section 133 clause 2
if all is a proper uniform prescribed, only these things are more. But besides that, she was also wearing a head. Right? That is the only distinction. So that's why the constitution gives itself carves out an exception for the sex. How can it be unreasonable for one and reasonable for other? What is the reasonable restriction? That is the scope of that which Madam was asking. Please explain that.
I will give you another example. It is six or for example, I go to a school and because I have a weak eyesight, I wear the specs and I use some funky specs. It will be covered under that restriction. So that if you see the articles which we are talking about, I am wearing a proper uniform. Above that, if I wear headgear, how is it disturbing? How can you state where is the thin line which clarifies that you are not obeying point number 1, 2, 3 as per the guidelines given? So that how will you define the reasonable restriction and what is the test for it? So logic by the virtue of the definition of open demand restriction, rational necessity. It basically means that any restriction on a fundamental right has to first be checked on the angle of proportionality, as well as the fact that it has to be a rational relationship between the object of the BSU and the restriction. Using that in mind, and if this test is particular scenario, what we can see is that the restriction was imposed to impart discipline, as well as to maintain a particular kind of parity of uniforms among all students. Leave aside discipline and all.
The object is
Wearing a hijab is not something against discipline.
the object is the education. Personal nexus will be imparting education, right? And why that particular headgear and hijab is being singled out? There may be many students instead of hijab, he may like to wear a cap, or he may like to wear many other things on the head, as per their own faith and constraint. But you are also singling out a hijab, the word is hijab, not other.
You can just, what can be a hijab or take the synonymous of that. I want to wear a scarf. For example, the Kashmiri girls will wear a scarf. You will call that also a hijab. So we are giving just a connotation to that. How do you differentiate? We want to have your views on it.
Because we do not find any reasonable nexus. That is the objective to say that.
We understand it's a difficult case for you, but this is how, your arguing skills are. The fact that any other religion would now next come up and use their essential practices or all their essential practices to come up with as an excuse for saying that this is an essential practice of the religion and henceforth we can use that practice in such religions. See, this listed institutions and the major role is to impart discipline as well as to impart education particularly. These religious beliefs cannot be said to be claimed as a right to be practiced inside such educational institutions. As is also taken with
One minute. I think you're answering but not by abstraction. It is that you have to establish the rationality, alright, between the notification and banning of hijab. Come on the point.
The logic there is the rational nexus concept that schools are viewed as an integral part of our children's lifestyle. And the fact that these schools are notable for uniform. And if a student is wearing something that is additional to the uniform, that will create a sense of lack of consistency. I will give you an example of many schools where there is no uniform. There are many schools in India also, live abroad, but in India also there is no uniform restrictions. How can you justify that? But this act singles out the fact that education institutions should not be a place where religion should be expressed in such a form that it creates any kind of indecency or immorality. Today it is hijab. Tomorrow it could be any other practice that they feel it is an essential part of the religion. And how is already
That is true. I was trying to just you are preconceiving something.
That it is an executive instructions, notification. It is executive instructions and notifications that banning hijab or it is under some kind of law.
individual right of one person to express their beliefs in one particular aspect of their life. That is inside education. But you know, I have a difficulty in understanding this, that you are saying discipline to be maintained. This is at a school level. Then what about the college people? The college students are allowed to wear, there was cases where the girls were not allowed to wear jeans and colored clothes. That is everywhere it is allowed. So when you are at a higher pedestrian, when you are going to the college, the technical education or legal education, whatever, like in our institution, at least in law colleges, we are said that on these particular day you have to wear black and white or black coat. But otherwise, you see in any university, people are wearing color tones. So how do you stop that? You still justify that the notification is correct, then you have to give us reasons. 1, 2, 3.
There has to be a justification for that.
Keeping that in all those circumstances, the objective is to impart education. How the objective is getting affected. Education, you check whether we are hijab, don't we are hijab.
I will help you with some other things also. I will just tell you that imparting education is not a, my dress is not going to say. Yes, if I'm taking some drugs or I'm under influence of liquor, I'm not allowed, you are not allowed to enter into the college or the school. So, you have to justify. These are the only questions now you can answer.
You answer too many questions of confusion.
All right, 1 minute. So this statement, can it be interpreted in the light of Article 25? What it says? Heading itself.
Article 25 under its ambit also covers essential religious tests, meaning thereby that if any practice has to be termed as an essential practice,
No, just
that is only
split
when
out the heading of the article. Heading, just heading.
Just see the top.
subject.
That is sufficient.
The opening words, however, says that subject to public order, morality, and other purposes of the religion or party. Restrictions can be imposed.
When these measurements are being satisfied when you propagate by virtue of the desire by the notification which is subject to the tax.
Lordship, the outward expression of one religious belief in a country where Judaism specifically is the minority religion, where Indiana has a massive population of individuals, where Judaism is a minority. In the state of Fallujah, however, it is the opposite. The Judaism population is the highest population. The manner of the tax is that to prevent any kind of disturbance inside the education institutions, that could be public disturbance, that could be an effect to morality, that could be an effect to education. So to stop that, hijab is one such method to stop it. The widest connotation of proper uniform covers all such aspects. Aspects could be even harmful to society. So hijab is one such aspect that covers the.
All right, Moot. We understand that it is very, very difficult for the respondent to establish, but even this court expects something more from the government.
You have to argue something against your conscience.
This is the job of the counsel. You have to argue for protecting your client's case. Sometimes you have to just put your own opinion behind.
Moving on to the next one of the arguments, it is stated that in the case of Sri Govinda Maharaj was the state of Rajasthan.
What is the second point? Just what are the argument? Now this hijab person is gone.
The article 19 one is gone, now it's article 25 is the one.
Take second subject.
So, second convention of the first article.
Hey, you're pretty fast now, come on the. The second issue, your lordship, deals with the challenges to the
It is humbly submitted before your lordship that even though Article 1 of the Constitution of Indiana grants to Indiana the status of a unitary state, yet in terms of its structure, Indiana is always inclined towards being federal in its nature.
Just one question. You're talking about Article 1. Before you move further, just differentiate between union of states and federation of states. And also, this court would like from you, under what background this union of states word was adopted by the Supreme Court of Constitution.
Union of states means that the states in that particular country, they have come together, they have been formed as a unit. So instead of accession, the Union of States was formed. Every state was given an understanding the instrument of accession at the time of the ADS. While a federation of states like in USA, what we can see that states came together to form a federation.
By way of?
By way of government administration.
By way of? Simply they have stand on road and stated that we are together.
By way of very negligible, but the fact is that they came together to form a federation of states, meaning that they will have a federal structure in the constitution. But Indiana as a state has a polite federal structure, meaning that both the state and the center are in power, but the center has a more higher protectment as compared to states in general.
So under such circumstances, they have right to secede from the state if they are union of states.
That it is a polite federal structure, that means that there are also federal features and federal features in terms of the structure of the country of Indiana, meaning that by that right to secession will also be given as part of it. Specifically, Article 1 specifically mentions under clause 3 that states will also include the laws of the Article 1. The laws also states that such other territories as will be acquired by the Union. The fact that the word acquired has been mentioned, it will also be presumed to be
You're misinterpreting. Acquisition of a territory is something else. Everything else is assumption for separation.
and that is what also because the Union of Indiana had ratified the international very important convention, that is the International Convention on Civil and Political Rights, that specifically under Article 1 states that people will be given the right to determine their political status by the virtue of the right to self-determination. Self-determination basically means that
Indiana people have not determined they exercise this right by adopting the constitution. Is it not the self-determination? When we say that we the people of, then meaning thereby that we have exercised the right of self-determination. And once we have exercised the right of self-determination, can't be is unending.
the fact is that the constitution itself is a matter of self-determination, but the fact is that this permanent was signed considering that it also grants to Indiana other rights, considering that Article 1 essentially states that India, the member states have the right to determine the polity that they want to be governed by, which helps them to develop socially and culturally in that sense. Your lordships, if your lordships can refer to the para 28 of the Moot proposition. The policy rights specifically mentions, since the Union of Indiana had ratified the Charter of the United Nations and the ICCPR, the Parliament of Indiana introduced the Constitutional Act, meaning that it was only after the ratification that the Constitutional Amendment Act was passed and that is secession was given as a right to the states as well. Your lordships, in this particular scenario, when we deal with the Constitutional Amendment and its validity, we have to be using the doctrine of the grounds of constitutionality. Means thereby that any legislation, act or rule that comes before an honorable bench has to be first presumed to be constitutional in nature, and only when it is exercised proven by the word petitioner that it is violating fundamental rights or articles of the Constitution of Indiana, then only the court can prevent it or the presumption. The lordship further is the duty of the honorable bench and the very honorable court that all the provision of the particular act has to be pursued in a manner so as to maintain stability and to sustain that particular provision instead of outrightly declaring it to be invalid. Your lordships, applying this doctrine to this scenario, we can see that this only when the ICCPR was signed by the Union, that the Union came forward with a law that gave the right of secession to the states of the country. Therefore, it is in line with the aims and objectives of the ICCPR by virtue of Article 253, which states that all the international agreements are
Just one. See, we have given the background of the proposition contains background of this problem. And the people people of Indiana, they fought from forefront for the creation of this country for a long period, right? And after that, they have decided certain rules which is already there in preamble also. So this amendment 106, don't you think it is against the will of the framer of the constitution?
And another thing I want to add, the councils are no one to tell the court that what is the duty and what is not the duty. You have to assist the court and you have to give efficient and ample material to the court, and then it is will be decided by the jury or the judges.
All right, my question is, if you just go through the bill of the people, framer of our constitution, our forefathers, okay? So they have decided certain principles which can be seen from the preamble of our constitution. And 106 amendment, don't you think it is going to their wish and wills for which they have framed this constitution?
Amended by the voting article 60 where both the houses of the parliament have to approve the same.
There are a lot of questions that simultaneously coming to you. Before you can answer, the second question comes in. But, what I would ask you is that, just now you advocated that the notification was issued after complying with the procedure. Now, if a notification issued after it is bound to be after complying with the procedure. But still, if it is contrary to the constitutional mandate or the basic structure of the constitution provided under the preamble, then still it could be sustained. You were advocating in the first phase of your argument that uniform plays a very important role. Maintaining uniformity in an education system also, but permitting to put on adjustment. But tell me whether you are in a uniform. There is a time. So how can you advocate that when you yourself you are not following it?
Are you wearing a tie? See how helpful
Don't fight outside the phone. Why you putting on uniform? Please.
And you have marked for that also. Vote etiquette, using.
that the state of Colombia can be given the right to secede from the Union of India.
Therefore, so far, both one is concerned, that way you are supporting your.
Your Lordship,
Yes, that the right to see is there.
Your Lordship, since we are representing the Union of Indiana, and Union of Indiana has passed the 106 Constitutional Amendment Act, which gives this right to secede from the Union of Indiana to the states. Therefore, Your Lordship, we are defending this right. Your Lordship, may permit, I can go through. One meeting, Your Lordship, this is Council number 2 appearing on behalf of the respondent. Your Lordship does not have any queries with the submissions of my co-counsel. The council would like to proceed with my submission. Your Lordship, as I have already mentioned that I will be dealing with the third and the fourth issue. Your Lordship, the proceedings of my third issue, that is the imposition of president rule in the state of Colombia was constitutionally valid, is based on two main contentions. First, Your Lordship, that is the imposition of president rule in the state of Colombia was based on constitutional principles, and by imposing the emergency, the union merely discharged its constitutional duty. And secondly, Your Lordship, there was a situation of failure of constitutional machinery in the state, as required by Article 356 before imposing the resident rule. Your Lordship, before going into my submission further, I would like to just draw your attention to the language of Article 355. Your Lordship, the Article 355 says, and it imposes two duties upon the union. First, it is the duty of the union to protect every state from external and internal aggression. And secondly, Your Lordship, which is the relevance here, that it is the duty of the union that every state is carried on in accordance with the provisions of this constitution. Therefore, Your Lordship, there is a constitutional obligation upon the union to ensure that every state is working in accordance with the provisions of the constitution. And whether it is a failure of constitutional machinery in the state or not is a matter of assessment which has been left upon the union to decide. And therefore, Your Lordship, when the union finds that there is a situation in the state where the state cannot be carried in accordance with the provisions of the constitution, the union can impose Article 356, Your Lordship. If Your Lordship may refer to para number 36 of the Moot proposition, Your Lordship, it is clearly mentioned that despite many efforts, the government lost majority in the state of Colombia and the coalition government broke.
One question. This Article 356 itself talk about the satisfaction of president, right? This court would like to know from you, how do you interpret this word satisfaction of president? What is it?
Your Lordship. Your Lordship, as the Article 356 says that the president is the supreme authority to impose Article 356. It depends upon the subjective satisfaction of the president. Your Lordship, the council tried its best to determine the scope of the term or otherwise.
No, both. In fact, sorry, you are adding a word to it. It's not a subjective satisfaction. It has to be analytically analyzed by the person.
Your Lordship, the council understands the concern. Your Lordship, if you refer to the language of Article 356, it says that president either on a receipt of the report from the governor or otherwise. Your Lordship, that term otherwise was clarified by the Supreme Court in the case of Rameshwar Prasad. The Supreme Court did not delve much into it, but Your Lordship, the Supreme Court held that the term otherwise would mean the subjective satisfaction of the union. But Your Lordship, there are certain procedures and safeguards which have to be followed by the president and by the union itself before imposing Article 356.
All right. One of the article, it clearly says there shall be a president of India with Prime Minister to aid and advise him. So it is generally understood the satisfaction of president is the satisfaction of your cabinet. Right? So under that backdrop,
If Your Lordship, the council would like to repeat your question that the Lordship is saying that the president, the will of the president depends upon the will of the cabinet.
He doesn't want to say that. He says that as soon as the president comes to a conclusion that the circumstances are as such, the president rule is to be imposed. That implies that there is a satisfaction of the cabinet. A decision-making process has already been taken.
Your Lordship, but Article 356 itself says that the imposition of president rule has to be presented within 2 months before the House of the Parliament. And if the report has been passed, only then the president rule will be continued further.
Council, it is withdrawn, not in session, then also it can be. It's a wrong.
Your Lordship, as per the latest council knowledge, there is no satisfactory judicial determination or any criteria which has to be, which would be a relevant consideration before invoking Article 356. Therefore, Your Lordship, Article 356, the question has been left intrinsically left upon the union to decide whether it is a situation of failure of constitutional machinery in the state or not.
Union or on some convention established by the India as well as abroad.
Your Lordship, it will go as per the bare language of Article 356. It depends upon the union only, Your Lordship.
Union word is used over here, which you are using in your address, is an abstract term. Now, in case if you want to do a subjective analysis to it, where the Article 356 uses that is the wisdom of the president. Wisdom of the president cannot be exclusive for the purposes of imposition of presidential. There has to be certain factors which are available to him to come to that conclusion. So what he wants to ask you is that, what will be the process to be adopted before the president takes a decision to impose a presidential?
Much of that, Your Lordship. Your Lordship, even the Supreme Court itself has laid down these procedures before the president has to be satisfied before using Article 356 directly. Your Lordship, first, an alternative chance, or first, Your Lordship, a warning has to be issued to the state government to correct itself. Even if after a warning, the state government is not correcting itself, Your Lordship, then a chance has to be given to the governor to install a caretaker government for the time being. Your Lordship, even after all these circumstances fail, then Your Lordship, imposition of Article 356 would be justified. However, Your Lordship, if you refer to the reports of the Sarkaria Commission, Your Lordship, it is mentioned in point number 6, chapter number 6 of the emergency provisions of the reports of the Sarkaria Commission, that these procedures which has to be followed before imposing Article 356 can be dispensed in cases of extreme urgency, where failure on the part of the union to take immediate action will lead to disastrous consequences. Your Lordship, what the council is trying to say is that it was a case of instant emergency, Your Lordship. There was no authority the state government was already dissolved, and it got dissolved at a time when there was outraging protest in the state. Therefore, Your Lordship, the intervention of the union became not only permissible but obligatory on the part of the union, Your Lordship. Your Lordship is satisfied, the council would like to proceed with the method of Your Lordship. Your Lordship, we have referred to the case of Rameshwar Prasad versus Union of India on page number 34, para number 4 of the Moot Court memorial. Your Lordship, they refer to it. The Supreme Court has held that the union is not expected to act as a passive spectator in cases where the state is failing to perform in accordance with the provisions of the Constitution. Your Lordship, the council is trying to say that the union is not expected to sit and watch the breakdown of the constitutional machinery in the state. It is expected to act promptly under such circumstances, Your Lordship.
Just one question. Whether the president rule was imposed on the failure of the state government to comply the direction of the union, or there was the dissolution of the assembly by the pulling out of the coalition partner. What was the reason of imposition of the president rule? This out of these two, because at one part you were saying that warning must be, you are saying, referring to Article 355 and 356. But in the present case, as per the facts of the case are concerned, first there was withdrawal of the support from by the coalition partner, and thereafter the president rule was imposed. So where the question of warning comes?
Your Lordship, in the present case, Your Lordship, first the protest happened, and then, Your Lordship, in response to that protest, Your Lordship, the state government got dissolved. Your Lordship, the Union of Indiana respects the right to protest. However, when there was no authority left to control those protests, after that, Your Lordship, the imposition of president rule was imposed. Your Lordship, it is mentioned in para number 36 that assuming the demonstrations and the breakdown of the coalition government, the president rule was imposed, Your Lordship. Your Lordship. until and unless a clear mala fide intentions are shown. And the burden of showing this mala fide intention lies on the petitioner, your lordship. Your lordship, the petitioner has decided the bench. The petitioners contended that the president rule was imposed due to the violent protests in the state. But as your lordship, the council has already verified that the president rule was imposed after the breakdown of the coalition government, when no authority was left to look after those protests, your lordship.
But petitioner's case is that the union has not given an opportunity to explore the forming of the alternate government, and they have not permitted, they have not directed that the floor test should be conducted by the governor.
Your lordship, when the president rule was imposed, just before that, there was secessionist tendencies in the state of Croatia, your lordship. Your lordship, it is contended that under such circumstances, where a state is demanding secession from the union, your lordship, a floor test would not be possible. Your lordship, the union government installed a caretaker government for the time being. Your lordship, when the protest would have cooled down in the near future, the protest would have been conducted or fresh elections would have been also conducted, your lordship.
Just argue in the light of SR movement.
SR movement.
The state of Pakistan was in India, both.
Your lordship, we have also referred to the case of SR movement.
This court had already given the white guidelines in this case.
Your lordship, the council also understands the concern. Your lordship, it is the council accepts the fact that imposing of Article 356 under these circumstances led to a serious inroad to the principles of federalism that is practiced by the Constitution of India. However, your lordship, this inroad is permitted by the Constitution itself, because as per Article 356, a subjective satisfaction of the president, a situation has arisen where the state government cannot be carried in accordance with the provisions of the Constitution. Your lordship, the Supreme Court in the SR Mumbai case also held that the truth and the correctness of the material. Your lordship, we have referred to the case of SR Mumbai, page number 35, point number 5. Yes, your lordship. The Supreme Court has also laid that the truth and the correctness of the material of the proclamation of emergency would not be questioned by the court until and unless a clear-cut case is shown that there has been abuse of power. Your lordship, it is also mentioned in the SR Mumbai case judgment that the Supreme Court said that it is not possible to limit the scope of Article 356 to any specific conditions. Therefore, your lordship, it is being contended that Article 356, which is such an extraordinary remedy, your lordship, it is imposed, it is used in such circumstances where, your lordship, sometimes the situation becomes of grave emergency. Your lordship, the incident case was not only a case of physical breakdown, but it was also a case of political breakdown in the state, your lordship. The government broke down at such a crucial point when the protests were outraging and the state was demanding the secessionist tendencies, your lordship. Therefore, your lordship, and
Just explain the tendencies, secessionist tendencies, what do you mean by that? And what is the, outer limit of the lower limit of that? It is very important because, you use this word 2-3 times.
your lordship, it is mentioned that in paragraph 38 of the Moot proposition, it is mentioned.
Want from you, what do you mean by that?
What do you mean by that? I don't know by that. How do you interpret that?
Your lordship, the secessionist tendency can be construed in simple terms that the people of a particular region want to separate from the bigger union, your lordship. And it would be because of different reasons. Either they are feeling neglected, or your lordship, the union, or your lordship, their demands have not been fulfilled, or there is a situation of utter chaos in the state, your lordship.
Meaning thereby, your government, union government, at one time propagate that there is a right of self-determination in such a way that a state can separate from the union. And at the same time, you want to say that these type of protests which demonstrate the will of the people of a particular state is enable the central government to impose the presidential rule. Don't you think that these two arguments are counterproductive? At the one time, your stand is that we propagate this freedom. At the same time, when they express this freedom, you want to say that this is the failure of the constitutional machinery.
Your lordship, the council understands this concern. Your Lordship, the Council understands this concern. Your Lordship, the right to self-determination to the states have been provided in reference to the signing and ratifying of the ICCPR and the UN Charter, Your Lordship. The provisions, there is a specific procedure which has to be followed if a state wants to secede. However, Your Lordship, in the instant case, there was utter chaos. There was violent protest, and if the state could not have acted promptly, the situation could have worsened, leading to loss of life and also the loss of properties, Your Lordship. Therefore, Your Lordship, the imposition of resident rule in the absence of a state was justified in the instant case, Your Lordship.
So when that's be taken as to be a substitute of the word satisfied used in under Article 356. Merely because there is a chaos in the state, merely because there is a failure or there is a religious animosity. Will that be substituting the word satisfaction used under Article 356 to bifurcate the state from the union?
Much obliged, Your Lordship. The term satisfaction has to be wide. It requires a greater level of satisfaction. However, Your Lordship, the instant case, Your Lordship, there was no state to control those protests, Your Lordship. Even if we have imposed Section 144 of the CRPC, Your Lordship, the Section 144 of the CRPC also says that the DMs and the SDMs under the control of the state government, Your Lordship. Then how could a state could have performed without the authority of law, Your Lordship? Without us government, how could a state have been performed, Your Lordship? It would have led to an anarchy rather than following a due process of law, Your Lordship.
Something like this one. The president does not have its own mechanism to get material within material to form appeal or satisfaction. It has to depend upon the two sources. One is report from the governor under Article 356, and secondly, other. Otherwise, well, it can be from cabinet or aid and advice of the cabinet of ministers and all. In the particular case, the logic of the government has fallen down. So otherwise, we will not understand. One would apply the governor's report. Was there any governor's report to the president to come to a satisfaction and apply his mind whether the president do that report or not? Or in the options of governor's opinion, when there is no otherwise part satisfied, how can the president rule can be imposed?
Your Lordship, as Article 356 rightly says that it has to be either from the report of the governor or otherwise, Your
So
Lordship.
therefore, it says the president on its own does not have any machinery to gather information. As this opinion of satisfaction has to be based on the sources coming from the two streams. One is governors, other is otherwise. Otherwise, you have just explained it, that you know it may be on the aid and advice of ministers, they will find, but here there is no minister because the ministry has failed, the government has failed. But even the government fails, the governor doesn't fail. The topic governor wins. And the president has to act through the governor only. In that circumstances, whether there was any report of the governor or in the options of report, how can the president rule can be imposed? Otherwise, part is not satisfied.
Your Lordship, the Council understands the concern. Your Lordship, it is mentioned in the Moot proposition that efforts were made by the Union to restore the government in the state of Colombia. However, Your Lordship, that due to the conflicting of opinions between the parties, the state government could not be restored, Your Lordship. And Your Lordship, the term otherwise in the Article 356 cannot be restricted to some specific conditions. The scope of the term otherwise is very wide, Your Lordship. And it would depend upon the subjective satisfaction of the President, Your Lordship. Either it can also be from the reports of the Cabinet Minister of running the Union Government, Your Lordship.
Okay, so here what will happen? There is no governor's report.
This is what the governor's report was not.
Not there. The Union of India has advised, or Union of the Federation has advised, produce some material.
Your Lordship, the Moot proposition is silent about this fact, Your Lordship. Whether a report from the Union was
No, once the board proposition is silent, you might have taken some prevention that would have been different.
It is not the question of law, it is the question of fact. When we say that there is satisfaction of the president, and you understand the president by his own cannot give any opinion, it is always he is consulted and he is advised by the council of ministers. When the council of ministers decides something, it should be on the basis of some material. There is no specific material in the moot court proposition, but you can presume that there might be some material placed before the council of ministers to arrive to a conclusion that that possibilities were explored to form a government, and it could not materialize. So this is the question. That this is the one thing is it is not the subjective satisfaction. When a satisfaction is recorded on the basis of some material, then it is always objective.
That's good. Move further.
Your Lordship, the council also understands this concern, but Your Lordship, the council would like to plead that the case was of a grave emergency, Your Lordship. If the union would have waited for the report from the cabinet ministers or a report from the governor, the situation could have worsened in the state, Your Lordship.
In that eventuality, you are making the use of word satisfaction has to be a nullity in the statute books. Because otherwise cannot be a substitute for the word satisfaction.
But Your Lordship, the bare language of Article 3 it says that the president, either on the receipt of the report from the governor or otherwise, Your Lordship.
That's correct. Then there's a comma.
Yes, Your Lordship, or otherwise.
That or otherwise cannot override the use of word satisfaction. Because for satisfying all three prior conditions, satisfaction is the prime ingredient to impose presidency.
Yes.
And another thing I want to add is what the other religious saying. You said that this particular state is a very diversified religion. In the beginning only it was said, right? And you are aware of this thing that anything can be accelerated at any time. So there is a diversity, and you said there was grave emergency. What emergency? Just tell us that. Usually these protests keep on going everywhere. So how do you correlate this emergency, diversity, religious differences as well as the report given by the cabinet? We could not wait for the report, and that is why we did this and we go ahead. We wanted to go ahead with this. So you have to correlate the whole things.
And you are representing center, you must be having some particular knowledge which was provided to you by the government, that these are the inputs on the basis of which the emergency was declared. That's what I'm saying.
All right, Council, just to add to your ladyship, you have used the word grave emergency. I think you are mistaken. This word has also been used by Constitution, but that is in Article 352. And when the grave emergency exists, then it has to go for national emergency, not here.
Yes, Your Lordship, the term has not been used as per the provisions of the Constitution. It was just a general
Just casually.
Your Lordship, to indicate a situation where there was violent protest in the state and the protests were already intensified. Your Lordship. Yes, Your Lordship, the council
Understand that.
Yes.
That's why, these are deliberate things, very, very simple things.
Yes, Your
It
Lordship.
is not a, some, very great protest going on, where some burglaries are going on, all this.
And when
Part of any
when
state.
you are supporting the legislation, you have to be armed with all kinds of machine and background. Right? I know there is normal saying is, all of you are going to get with the council. The council always has to think what it takes. Don't remain confined to your brief. Be something more than that.
I would add one number that I said that when you are arguing the matter, the presumption which we are drawing is that your client has briefed you everything for the purposes of justifying satisfaction to your obligation issues, but that is not being diverged.
Your Lordship, we have nothing against the state of Fallujah. In the next issue, we are also giving them the right to secede, provided they pass the 106 Constitutional Amendment Act test. Your leadership, as your leadership has mentioned, that a situation of law and order is different from a situation of failure of constitutional machinery in the state. But your leadership, a situation of law and order is a condition precedent that can turn into a condition of failure of constitutional machinery in the state. And your leadership, in the instant case, the situation of law and order was accompanied by a political breakdown, where there was no authority, where
You have one more issue.
raised the council like
Come on, relax.
मैं पोस्ट किया था तो यहाँ पे लोग पुलिस वाले को बोल दिया तब तक विजुअल मारो
summarize You're also moving on to the contention of the fourth issue, that is the state of closure can be given the right to secede. Your Lordship, it is mentioned on para number 28 of the Moot proposition that the Union of Indiana has ratified the ICCPR and the UN Charter. Your Lordship, by virtue of Article 1 of the ICCPR, it states that all people have the right to self-determination, and by virtue of that, they are right to determine their political status. And Your Lordship, by virtue of Article 253 of the Constitution of Indiana, which gives the Parliament the power to pass and legislate in order to implement the international agreements. Indiana has the duty to formulate these rights into its own constitution, Your Lordship. Not only Article 253, but Article 51 of the Constitution also specifically mentions that.
That's one point. Just now you argued before that, if this amendment is done after following the certain procedure. This court would like to know what is the procedure to have this amendment under Article 368. There are three ways to have a constitutional amendment.
Your Lordship, the amendment to the Constitution can be initiated in either house of the Parliament.
Not that.
It has to be passed in each house by total membership of that house and not less than 2/3 of the majority, Your Lordship. Then, after getting passed by both the houses, it has to get the.
All right, you move on, because you have already time also. Come on, final, fast.
Yes, Your Lordship. The Council would just like to represent is that by virtue of Article 51 of the Constitution, which specifically mentions that the state shall respect all the provisions related to international law and shall make best efforts to fulfill its treaty obligations. Your Lordship, what the Council is trying to Amendment Act itself, that is a referendum, and then it has to go through both the houses of the Parliament, Your Lordship. Your Lordship, on one hand, we had a duty since we have signed the ICCPR, we had a duty to formulate these laws. On the other hand, we have provided a strong safeguard that any state cannot be given the right to secession so easily, Your Lordship. If Your Lordship does not have any queries with the submission, the Council would just like to raise the case with the press. In light of the issues raised, arguments advanced and the authorities cited, the Council for the respondents humbly prays before this honorable court to please adjust, hold and declare that the notification issued by the state government of Croatia under section 133, subclause 2 of the Croatia Education Act, pertaining to ban on entry of students wearing hijab in schools and colleges as constitutional and not violative of Article 19(1)(a) and 25 of the Constitution of India. Secondly, Your Lordship, 106 Constitutional Amendment Act 2022 to be declared as constitutionally valid. Imposition of President's rule in the state of Croatia to be declared as constitutionally valid. And lastly, Your Lordship, the state of Croatia can be given the right to secede from the Union of Indiana provided they pass the test of the 106 Constitutional Amendment Act and pass any other order that the Honorable Court may deem fit in the interest of justice. It was a pleasure.
You opt for the rebuttal?
You are rating any viewpoint, then they also have a right to.
I will not raise any, I will merely rebut the argument. Lots of emphasis have been given on the point of parity and equality in the context of uniform. I must contend that I do not look as part of my colleagues sitting in front of your Lordship as I am very tough. But this esteemed institution has still been some basis in this competition. Now, because I am covering my head, can it be said that I am not wearing uniform? In my humble submission, the answer is resounding no. And the second point is, my Lord, the AK Gopalan jurisprudence has been cited. That the Lordships are aware that the AK Gopalan jurisprudence has been disagreed upon by Lordships in subsequent benches in the bank nationalization case. And in the recent judgment, just now, a few days back, in Boston Kishore versus State, the judgment rendered by the Lordship P. Raman, clearly said that while imposing restriction on Article 19, the list is very exhaustive. No other interpretation, no vague restriction under the guise of social interest or social order cannot be moved. My lord, the third is they said visible expression. Now I must take your lordship and my lady to the Constituent Assembly debate. My lord, there was a member in the Constituent Assembly debate representing the Jammu Hussain. My lord, he brought an amendment to the draft Article 25 that India being a secular, there should be a proviso that no visible expression of religion should be there. The amendment was rejected by the Constituent Assembly. My lords, next is right to livelihood has been invoked to justify the right to self-determination. My lord, the right to livelihood, which is provided by the Constitution, is now put against the Constitution. My lord, another most important is religious oppression, the reason which is applied for secession, religious oppression. My lord, if at all there is religious exploitation, then I must ask myself only, then why your lordships are here? In the words of Chinappa, the Lord Justice Chinappa Reddy, your lordship have and equal. Now the another point is my lord, I will just cover in 30 seconds. In just 30 seconds. My lord, they said union is not expected to be a mute spectator. My lord, indeed, the proposition is right. Union is not expected to be a mute spectator in a case of disturbance. But my answer question to myself is very good disturbance. Is mere protest is a disturbance? Going by that proposition, my lord, just now Kisan Andolan happened, going by that proposition, Union of Territory was a fit case to pose President to my humble position is I'm pretty so. My lord, last is I see your lordship. Please, my lord. Alright, this is how I read it.
Regarding the third amendment, as I government petition the voting stated in the amendment, your lordship, the first was that the wearing of turban has no meaning and in purpose. The argument is that in this particular case scenario as well, we're not specifically saying that hijab is banned. In general, anything that is not in the proper rules of uniform is banned. That means that even turban as a right is not mentioned anywhere in the law. And Article 25 is when only kirpan is mentioned. Meaning that the word proper uniform can be also connotated to mean other things, which are except turbans or except headscarves. Your Lordship, it is also submitted that regarding the argument about the third issue that the union cannot be a mute spectator, it is submitted that the fact that there was a disturbance in the state of Croatia to an extent that even the government has broken down and the numbers have failed. Meaning thereby that the situation demanded that there should be immediate action and a prompt action in that regard. And that prompt action, when the government is involved, could only be coming from the union in general, because the union, as I have already mentioned, has the right to protect the states in terms of emergencies, in terms of any disturbance that the state government is not able to cater to. So in this regard as well, since the union had the power to do so, the union took a prompt action and took will conduct a protest even only when the entire situation has cooled down and the state government is restored in the